name is Charlie Satterwhite, and I'm the Circuit Judge for the 15th Judicial Circuit. And I'm going to be talking with you for a few minutes about how the court system in Kentucky works. The Kentucky court system as it presently exists came about as a result of an amendment to the Kentucky Constitution in 1976. And as a result of that dramatic change, we now have what is called a unified court system. But before I get into the actual court system itself, just as a basic civics lesson, I think that we are all familiar with the fact that there are three branches of government. And those three branches of government are the legislative branch, the executive branch, and the judicial branch. And of course, the legislative branch is the legislature that meets in Kentucky, the representatives and the senators, and they're the ones who pass the laws that determine our activities here in the Commonwealth of Kentucky. And then when those laws do get passed, it is incumbent upon the executive branch of government to enforce and implement those laws. And then it is the responsibility of the judicial branch of government, which we'll be talking about more today, to make sure that there is a fair enforcement and application of those laws that are being enforced and that got passed. We are under a constitutional form of government, and the legislature has authority only to pass laws that conform with that Constitution, and the executive branch must make sure that there is a fair and impartial enforcement of those laws which have been passed. And it is the judicial branch of government, the court system, that is to make sure that that does in fact take place. The judicial system that was created by the amendment to the Kentucky Constitution in 1976 did create the unified court system, which means that it is all under state government, whereas in the past it had consisted of different types of governments being responsible for the court system. There were smaller courts in some of the counties and the cities, and as a result of that amendment, we are now under one unified court system. And the court system has four separate branches within that, and that is the Supreme Court, the Court of Appeals, the Circuit Court, and the District Court. But the entire judicial system is based upon the understanding of what we call an adversarial system of law. And what that means is that there is a belief that the best way to get to the truth of a matter which is in dispute between two or more parties is that those people can come to a fair and an impartial proceeding, which is provided by our court system, and that each side can present its position on the controversy before it, and then have a finder of fact to resolve the disputes before them. And that can consist sometimes of just a judge, or sometimes will consist of a judge and a jury. But that's the function of the court system, is to provide that fair and impartial forum where people can come with their disputes and have those disputes resolved. And what I intend to do today is to talk about the roles of the Supreme Court, the Court of Appeals, the Circuit Court, and the District Court, and what the functions are in each of those parts of the court system. The Supreme Court is the highest court in Kentucky, and then the Court of Appeals is next below that. The appellate court clerks are the ones that are responsible for keeping the records of those appellate courts. Then there is the Circuit Court and the District Court, and the Circuit Court clerk is responsible for maintaining the records that are produced as a result of action in District or Circuit Court. And now we will talk about these various courts actually in inverse order. The District Court, and that's what I like to refer to as the People's Court. 90% of the people who have any exposure to the court system in the Commonwealth of Kentucky will have that exposure in the district courts. And that is the courts where that people who are charged with minor crimes, who have traffic tickets or other matters, will come to court. In fact, almost everybody at some time or another will either come to district court or have a matter come to district court, because it is also the court which you would come to for handling all probate matters. And listed below this are the types of things that come into the district court. District judges are elected, as are all judges in the state of Kentucky. District judges are elected for terms of 4 years. And the there is at least one district judge for each area, and there can be more than one county in a particular district. In the 15th Judicial District, there are 2 district judges, and they cover the 15th Judicial District, which is Carroll County, Owen County, and Grant County. The types of matters which can be brought before district court are juvenile matters. And a juvenile matter is when someone who is under 18 years of age has been charged either with the commission of a crime or who has been charged with something that because of his or her age has made that activity against the law. For example, truancy matters, where somebody does not attend school on a regular basis, someone who does not obey his or her parents, then those people can be brought to juvenile court for a decision by a district court judge. As you will notice, I've put here that in juvenile matters there is no right to a trial before a jury. Only the judge will hear those matters. All matters which take place in juvenile court are confidential, and that means that the public cannot come in and listen to the matters which take place in juvenile court. It also means that the public nor the press has the right to access of the records which are generated in those juvenile court matters. City and county ordinances. The city and counties will have ordinances that they adopt, and if people are in violation of those ordinances, then those matters would be brought before the district court. Misdemeanors. A misdemeanor, by definition, is a crime, and the punishment that can be imposed is no more than a year in a county jail or a monetary fine. The difference between a misdemeanor and a felony is that with a felony, a person, if convicted, could go to prison. But if a person is charged with misdemeanor, he or she is tried in district court. And you will notice that in the charge of misdemeanors, a person has the right to a trial before a jury. In district court, we have jury trials, and those juries have 6 people on them. But in criminal cases, it still must be a unanimous verdict. The person is presumed not to be guilty and has the same rights as a person who is charged with a more serious crime. If the person cannot afford a lawyer is appointed for them to represent them free. But misdemeanors are tried in district court, and there is the right to a trial by a jury. Traffic offenses. When a person gets charged with speeding, when a person gets charged with drunk driving, any matter that is a traffic offense also gets tried in district court, and again there is a right to a trial by a jury. Indicated earlier that probates. I've put here probate of wills, but whether there is a will or whether there is not a will, when a person dies and leaves an estate of any amount, then people must go to court to be appointed to represent that estate. And that's where these people would go before the district judge. Papers would be filed asking for their appointment so that the matters of the estate could be taken care of and the estate would be settled. So the probate of wills, as well as the probate or the handling of estates where there are no wills, takes place in district court, and of course in those matters it's only before the judge. There is no right to a jury trial there. Felony preliminaries. When a person is charged with the commission of a felony, he or she is not tried in district court, but as a general rule, that